They have said that the insolvency process now needs to be mandatorily, completed within 330 days, and this should include the time spent in litigation. The pending cases, they have said, will get 90 days once this amendment comes into effect. They haven't, gone further to say they automatically go into liquidation, but I'm assuming that that's the effect of it. 330 days, Nilang, how feasible given what we have seen in the last 3 years? And also you had some concerns on what litigation period can be sort of excluded from this 330 days.
No, I think certainly more feasible than it was when we had only 32 judges, and now with the significant addition to the judge roster, I think that will be, it'll give us a chance to achieve this timeline, I think. But we'll have to wait and see what kind of litigation it is and whether courts look at this as directory or mandatory, etc. I mean, it does say it's mandatory, but we'll wait and see how courts interpret it. No, I guess what I was saying earlier, Paswani, is that what it's saying is that the CIRP period must end in this timeline. The CIRP period ends when a resolution plan is approved by a adjudicating authority or the NCLT, which means that after it's approved, if there's ongoing litigation, I don't know whether that is curtailed by virtue of the 330-day diktat.
So if I were to take the example of SR Steel, after the Gujarat NCLT approved the ArcelorMittal resolution plan, all of that which has happened after that needs to be excluded from this 330 days?
Well, as long as that, if you were to take an analogous example now, as long as that NCLT approval came in within 330 days, I think it'd be fine. The fact that that plan was then challenged further to NCLAT and then Supreme Court, I don't think is an issue under the 330-day guideline. I don't think that means that you'd have to go into liquidation because you have finished the CIRP in 330 days. The fact that after finishing the CIRP, someone has challenged the finishing of the CIRP, I don't think that's the issue here.
It's a good way to look at it because the CIRP wouldn't finish if there was an attendant litigation stopping the CIRP itself. And what the amendment is telling you is, okay, go ahead, do all of that, but 330 days is all you have. And that's the experience we've got from the 600 plus issue with SL. Right? So anything that comes after the CIRP is obviously not included in this. That is a different thing altogether. Because once the CIRP is done, you've either got the resolution plan approved and an order passed by the NCLT, or it's gone into liquidation. Right? There is no other option there. So it doesn't matter. Any litigation that we're talking about here is going to be only that litigation which held up the CIRP. So what the amendment's trying to tell you is that finish all of that in 330 days max.
So essentially,
so warring bidders between the, before
29A, is this guy even qualified? This is not fair and equitable. That's going to come up a lot.
So it's certainly very, very helpful because it certainly get to a point by which your plan is approved by NCLT in 330 days. That's very helpful.
But it could continue to get litigated post that, and it doesn't mean that you have to go into liquidation. Should they now specify post-approval timelines as well?
It's clear. I mean, there is no doubt, at least, in how that's going to pan out. So any other addition to that would just be a very prolix sort of a draft.
Okay.